coming.
Welcome to the Fearless Floyd Show. I'm your host, Fearless Floyd, as always. And guess what we have? We have a live show on YouTube with Christopher Hauser. So, without further ado, let's dive right in and see what Chris has to say.
I think the limit on 1099A is 1,000. Monetize the claim bond and send that with the assignment agreement and the treasury contract. That's it. When you guys with the bonds, the $1 million bonds, monetize the back and create the assignment agreement, assigning the bond to the Secretary of the Treasury, and then write the contract with the Treasury, giving them a percentage to collect. There's a few of y'all already have done that and sent them out. I've seen a few messages come across there where the bond guys are going after it. And look, man, I pray that this whole deal with the bond thing is straight. If you look at the definition of bond, you're going to see that they're monetizable, and they are worth something. They have value. So I'm hoping that they start paying out.
Couldn't agree more.
If you have a Social Security number, then it is tied to the Sesticate Trust.
It is.
The trust is not a bank. Yeah, the number is just an identification. Any trust that has a beneficiary in it is a Sesticate Trust.
No, that would be incorrect because it's from the Tucci-Jarraf Act of 1666. That's incorrect information. If I have a trust set up and my daughter's my beneficiary, that's not a Tucci-Jarraf trust. Absolutely not.
The penal bonds, using the 1099As, as soon as this works one time, I am going to blast this stuff out. A lot of y'all are really interested in that, and rightfully so. We've got so many loved ones out here crammed up in these dinky cells. That need to be released. It's crazy at the people that are locked up. I was just telling my wife earlier that when I was at Bledsoe, which is a transitional prison, I had to sell him. They didn't even move him out of the prison, out of the transitional prison, because he only had 45 days before his time was flattened. They brought him in there just so they could put him in the system one more time, instead of just letting him slide his last 45 days. They brought him in there over some piddly stuff so that they could issue him.
And I'll tell you a story similar to that. I worked with a guy in the laundry who had 20 years and picked up a 5-year stacked sentence consecutive for possession of marijuana in a penal institution. So he had 25 years. So he did the 20 flat and then started on the 5. He got to 20 years and 10 months and a couple days. And they were giving him parole lay-ins, and he would bring him to work, showing to me, hey, look, Floyd, these fucking fools. Excuse me. They gave me a lay-in for parole review. Man, I go home in like less than 2 months. And he'd throw it up in the air. The next day, he'd bring in another one. After like 4 or 5 days of that, these fools came to the laundry, escorted him to the parole office. The parole office told him, you are going home tomorrow morning on parole, whether you like it or not, even if we have to handcuff you and carry you out to the bus to take you. Absolutely. And this guy did 24 years and 10 months and probably 2 weeks on a 25-year sentence. So in like less than 45 days, he would completely do it, be off paper, just kiss my ass, holler at you, goodbye. And that's what they did to him. Yeah. So exactly what he's talking about. I've experienced it, been there, done that. That's why I tell you guys, there's nothing I haven't seen, haven't done, haven't experienced. Let's catch back in here with Chris.
Some more clothes and have him in the system and make money off him. There's thousands of dollars charged against the inmates' trust every day. We need to get these folks out. As soon as I get this information where I know it's effective, I'm going to share it. I'm going to put it all out on this. Paul Crane, thanks a lot. I appreciate you connecting me with Rose. She is a fantastic woman. She's outstanding. I really cherish the conversations that we've had, along with a few other folks that I've met in here. I truly call a lot of you all my friends.
And with that, I'm going to have to get on to my video. Thank you, Chris, for being live on my show. Sorry you couldn't actually be on the show, be a part of the show. And again, this is not a hit piece on Chris. This is asking the questions. Are we pursuing the same path? Abso-freaking-lutely. Yes. He wants off parole. He's on parole till 2030 something, remember? He wants off. I want off. Everybody wants off parole. We need to get these people out of the warehouses. But believe me, we don't need to open the floodgates and let them all out because some of them deserve to be there for the rest of their dang lives, even though they may not have enough time to do that. Because I've been locked up with those people, and they are predators. Abso-freaking-lutely. And they don't deserve to be out here in society. But they're going to be back out here, and they're going to reoffend. Absolutely. So, do people change? Yes. People change. People mature. People become more wise, more experienced, more laid back, for lack of a better term. Time, my thought. But anyway, let's dive into this. Again, thank you, Chris. And look, man, I applaud the guy. He's trying to do the right thing. I just have a lot of questions that need to be answered. Okay, I'm not the one beating him up on YouTube. That's somebody else who I invited to the show, and you saw their reply. So let me stop sharing that. We're going to dive right back in. Whoops, sorry. That's the wrong tab. Oh, man, I closed it out on accident. Yes, I did. So, open all that up.
Google Fi, a phone plan by Google. Get
Nope, that's the wrong one. Kidding me. That's not good. All right. On appeal, each defendant raises several issues, some for the first time. To complicate the appellate review, some issues were abandoned or framed in different language, first one by the defendant and then by the other. Defendant Hauser argues that the evidence is insufficient to support his forgery convictions, that the trial court improperly commented on the evidence by affixing labels to the outside of file folders that held exhibits, and that his sentence was excessive. This is Defendant Cooper's arguments, Defendant Lyons, Defendant Cromwell, Defendant Usinger analysis. This is on the venue, which It's useless, but I'll read it. On appeal, defendants Cooper, Lyons, Cromwell, Usinger claim the trial court erred by denying motion to dismiss based on improper venue in Davidson County. The motion cites Tennessee Rule Criminal Procedure 8, but points to language that appears in Tennessee Rule Criminal Procedure 18. Defendant Usinger, Cooper, and Cromwell also argue that the Waffle House shooting, which took place on the morning the defendant's trial started, mandated a change of venue because the criminal suspect and his potential affiliation to the sovereign nation painted the defendants as domestic terrorists. Defendants also argued the state failed to prove venue at trial. The state, on the other hand, disagrees, insisting that the state properly proved at trial that at least one element of each offense took place in Davidson County. And I can go in and read you all this mumbo jumbo where they cite laws and precedent case law to uphold their opinion and refute the arguments of the appellants or defendants. This is the forgery. Basically, after a hearing prior to trial, the trial court determined that the fact that the documents had to be filed with the Secretary of State in Davidson County establishes venue in this county. The trial court acknowledged that while the state could have filed charges in the respective counties where the real property subject to the liens was located, which would be multi-jurisdictional, that's the terminology, located, or where defendants computer filed the UCC documents, filing in Davidson County promoted judicial economy. We conclude the trial court's pretrial ruling on the motion to dismiss was proper, as well as they could have used the jurisdiction of the debtor's address, which would have been amenable too. So as you can see, because there were 302 counts that encompassed multiple jurisdictional areas, i.e. counties of Tennessee, for judicial economy, that's a legal term, they consolidated it to one county. One county. Okay? So that's what they did. Every court above this court is going to uphold that. Absolutely. The evidence needed to prove venue merely needed to satisfy the preponderance standard, which is more likely than not the more stringent standard beyond reasonable doubt, which is your criminal trial. Preponderance of the evidence is more for civil. As I say, it's a commercial proceeding under civil rules and procedure, masquerading as whatever they label it. The evidence at trial did not preponderate against the trial court's determination. At trial, Mr. Burton testified that it mattered not whether a lien was delivered by hand, by mail, or electronically. It was not filed until it was placed on a server that's located in Davidson County. Moreover, the jury heard the evidence and obviously determined that the state established venue. The issue is without merit. Boom. Told you. Okay. Lyons, he's arguing these different counts. Change of venue, and this mentions Chris, so let me dive in here. Defendants Usinger, Cooper, and Cromwell claim on appeal that the trial court abuses discretion. That's what would be called the abuse of discretion standard in denying a motion to change venue filed by defendant Cromwell prior to trial. And the motion defendant Cromwell, see, what they should have done right then and there is done an interlocutory appeal. An interlocutory appeal does not appeal the the judgment of the case, because the case would have to be finalized. What it does is it stays the proceedings, which means they're held in limbo. Okay, nothing's happening, and there's an appeal on that particular issue, which is the abuse of discretion in denying the motion change venue. They could have appealed that, stayed the proceedings. However, they did not have a good attorney or attorneys, obviously. That's what you would do. Okay. In the motion, defendant Cromwell indicated that an alleged sovereign citizen killed several people at the Waffle House in Nashville on the day prior to the start of the defendant's trial. The Waffle House tragedy resulted in a heightened media stir with some publicity regarding sovereign citizens, a group with which the defendants were alleged to have associated. Defendant Cromwell argued that the trial should be moved to a different venue to avoid prejudice. A discussion of the motion on the morning of the trial seems to indicate that defendant Hauser joined in the motion, at least orally. However, the technical record does not reflect that either defendant Usinger or defendant Cooper joined in the motion or filed their own motion to change venue, either pre-trial or otherwise. And basically, this gives you more of the case law and their argument and their opinion to support their rebuttal to the appellant's and defendant's arguments for relief. And basically, this is all legalese. Because defendants Cooper and Usinger failed to file a motion requesting and change of venue, this issue is waived. They bring it up in their issue for motion for new trial, which is not the place to do that. Issues which are not supported by citation to authorities will be treated as waived in this court. Cromwell brings on more. And moreover, defendant Cromwell does not point to any specific instances of prejudice in the record that would have precluded him from receiving a fair trial. Instead, he cites one authority, State versus Hoover, and makes vague references to defendant Hauser's defense theory that the liens were filed because they were sovereign citizens to support his claim that the trial court erred in denying a change of venue. Okay, so, is this really what Chris stated? The defense theory that the liens were filed because they were sovereign citizens? You want to connect that with that? Man, I'm not a sovereign citizen, don't want to be a sovereign citizen. Sovereign citizen's an oxymoronic statement or phrase, so it doesn't make any sense. I'm an intelligent being. Why would I want to be an oxymoron or even associate with it? I wouldn't and don't. And I refute the terminology. And this explains in Hoover. Basically, this is breaking down the case that they cite, Hoover. And Cromwell's not entitled to relief. Severance. Basically, severance is where they try to split the defendants so one can have a trial on this date or in this venue or in this other courtroom at the same time or a different time. They want to sever the defendants. However, because of judicial economy, probably going to see that term in here again, they tried them all together. Okay. Defendants Cooper, Lyons, Cromwell, and Usinger challenged the trial court's denial of their motion to sever their case from defendant Hauser. The four defendants filed this motion during trial after the opening statement of defendant Hauser, during which counsel claimed that defendant Hauser was tricked into filing the liens. In the motion to sever, the defense argued that defendant Hauser implied that the men were part of an anti-government group and that severance was necessary in order to avoid prejudice. The trial court denied the motion from the bench, commenting that the court would go over with the jury again that there are 5 different defendants. They're separate, and that they may hear testimony about the other, but they have to consider each defendant separately. As the jury was brought in the courtroom that day, the trial court reminded them, but that's the wrong terminology. The court admonished the jury. Okay, and this is basically what they admonished them with, that statement. Because the trial court provided limiting instruction at trial. That's the admonishment. Joint trials of defendants who are indicted together are essential to the promotion of judicial efficiency. Okay, there's that judicial economy. I told you that was going to come in here. And serve interests of justice by avoiding the scandal and inequity of inconsistent verdicts. Okay? That's Supreme Court case law right there. That's law of land. That's not state. That's you get. Basically, this is the standard of review, as it's called. The rule of joinder promotes judicial economy and efficiency by encouraging a single trial for offenses arising out of a single criminal episode. I told you, man, I used to live and breathe this, so this is all, I've forgotten more law than most attorneys will, you know, do their whole entire career. Let's see, page 19 of 36. I'm about to lose my voice, but the show must go on, right? This more legal mumbo jumbo, but and y'all can go look this up. This is TennesseeCourts.gov, tncourts.gov, and you can look up these cases. So this isn't something that's hidden or I only possess. This is free in the public sphere. You can go look it up just like I did. And this is all the case law to support their severance ruling. Okay, defendant Cromwell. Excuse me. Defendant Cromwell argues the trial court abuses discretion in denying motion to sever because trial counsel for defendant Hauser violated the trial court's ruling that the parties were prohibited from implicating the defendant's participation in the sovereign citizen movement by repeatedly mentioning the Knoxville Patriot and the leadership by defendant Cooper in ways to redress government grievances as part of his severance argument. I got the hiccups. Defendant Cromwell suggests that the trial court should have also granted a mistrial. We disagree. Prior to trial, the trial court determined that the defendant's participation in actions as sovereign citizens was not relevant to the proof at trial. Despite this admonition, defendant Cromwell complains that counsel for defendant Hauser surprised the other defendants by introducing a defense theory that attempted to prove that co-defendants had intended to file liens, but that defendant Hauser lacked intent due to his involvement in the sovereign citizen movement and had been coerced by defendant Cooper. And I find that mind-boggling, but it is what it is. In our estimation, the severance was not necessary to promote the fair determination of guilt or innocence of one or more defendants. Trial court considered the request for severance early in the trial during the jury out hearing, basically without the jury present. And based on its decision on the proper legal standard, the trial court told the jury to mindfully recall from the outset the defendants were all separate and properly instructed the jury as such. That's the admonishment. The jury is presumed to follow instructions given by the trial court. That's standard law across the board. Blah, 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 blah. Citing defendant Hauser's opening statement in the cross-examination of Mr. Birdsall, defendant Cromwell insists that his case should have been severed. To the contrary, defendant Cromwell has presented no evidence to overcome this presumption. The opening statement of defendant Hauser did not mention defendant Cromwell by name. Moreover, argument of counsel is not evidence. Additionally, Mr. Birdsall did not mention defendant Cromwell by name during the cross-examination by counsel for defendant Hauser. We conclude the trial court did not abuse its discretion in denying to defendant Cromwell's motion for severance based on a finding that severance was not required for a fair determination of guilt and innocence. We also determined that defendant Cromwell has waived any challenge to the trial court's failure to declare a mistrial. Defendant Cromwell did not ask for a mistrial during the trial and raised the issue first time on appeal. The issue is waived. Didn't bring it up in trial, it's waived. Like a bad indictment. If you don't bring it up during the trial, it's waived. Okay. It's on defendant Lyons. Usinger. Labels on the outside of the exhibit folders. They all argued on appeal. Trial court properly commented on the evidence by separating multi-page exhibits and placing them in manila folders with labels on the outside of the folders containing the exhibit number, the counts it related to, the name of the defendant, the UCC filing number, the alleged debtor's name, the filing date, and the amount. Okay. Look, they could have easily taken every one of those UCC ones, every one of them, all 302 of them, and handed each one to the jury and have them pass it to all 12 jurors. Every exhibit, absolutely. And instead, they were kind enough to put them in a manila envelope and just put a label on the outside and leave them laying on the table inside the bar. Okay? So they actually kind of did them a favor, and these guys are arguing about it. Okay? They could have easily put it in their hands and let them read it word for word. Okay? Which has more tangible effect. Okay? And this just appeared to be a representation of the court of some sort. These are just, pretty much useless, baseless arguments for the sake of arguing, because there really is no leg to stand on, no dog in the fight. Counsel for defendant Hauser went on to explain that his client contested the value of the documents. For the trial court to place a value amount on the label on each exhibit would be inappropriate. Well, all the trial court did was take the information and just put it on the outside because they did. I don't find that prejudicial. I don't find that in any shape or form to what they, this is the legal term, this is the legal phrase they use, to inflame the minds of the jurors. Okay? And I've read this stuff over and over and over. So when I read this, I already know. So I'm kind of breaking it off to you because I know none of you guys have read this. So you should understand what this is. And this isn't to vilify Chris or vilify his counselors. Now, apparently he had a lot of them and still has them. I just have a lot of questions that, you know, should be answered, but they're not. There's no answers to these questions. And I'm raising valid, on point questions. And I'm probably going to get beat up for this. And I'm sure there's going to be a tremendous amount of comments that are negative, not positive. And of course, nobody wants to hear the whole story. They're just hearing, what they want to hear, and then they're going to put it out there. Oh my God, Fearless, you're such a little man, or why are you vilifying Chris when he's trying to do so much good? Hey, yeah, but Chris, if you're this, why are you doing that? Or why haven't you taken care of that? Text. Yes. Let me keep going here. Actually, let me. All right. At the outset, we note the defendants Cooper Cromwell Alliance did not make any contemporaneous objections to the trial court's handling of the exhibits. They let that ride, which, as well, they should have. Referring to witness titles. Skip over these other guys. Chris didn't even address any of that. That was the other four guys. Sufficiency of the evidence. All five, and this is one of the most most used grounds of error on direct appeal. Sufficiency of the evidence, and sufficiency of the conviction as well. Those are two. All five defendants challenged the sufficiency of the evidence with respect to their convictions. While defendants Cromwell, Cooper, and Alliance challenged their convictions for forgery and fraudulent and filing lien, defendant Hausers and Usinger appear to challenge only their forgery convictions. Well, those hold the greater sentencing because they're a Class A felony in Tennessee, which have a greater sentencing range. The state disagrees with defendants, insisting that the evidence overwhelmingly supported the verdicts on all counts. Of course, You know, Chris definitely admitted that he did this. Well, they did when they did the change of venue. So they really can't argue the point. I mean, it's moot from the word go. As soon as you tried to address the venue, you hung yourselves, shot yourself in the foot right in front of the court. Forgery, each of the defendants indicted on multiple counts 40 pursuant to that. This just goes into more legal mumbo jumbo. Defendant Cromwell, defendant Lyons, Huizinger, defendant Cooper, and defendant Hauser. Now, before I go on, tab. All right. Now, as we know from part part one and two, the neutral neophyte, Mr. Harvey Dent, has accused Christopher Hauser of having connection with Heather and Tucci-Jarraf. I don't know who wrote this. Apparently, these are images of her. And I know just as much as you guys probably know. Some of you obviously know more than I do about her. Here's her case. An alleged trust fund of government money. The money was not his. Along the way, two of them defrauded the United States of $31 million. Okay, so let's just open this up. United States Court of Appeals for the Fifth Circuit. So that means they have federal conviction. They did an appeal. This is appeal to the Sixth Circuit. United States of America versus Heather Ann Tucci-Jarraf and Randall Keith Bean. I have no idea who he is. Appealed from the United States District Court for the Eastern District of Tennessee at Knoxville. Is that a coincidence? I don't know. This is what I'm reading, okay? I have no idea who these people are. I totally plead ignorance. If I did, I would tell you guys. I think you know that. Counsel, this is the opinion. Circuit Judge Sutton, faced with financial challenges and rising unpaid bills, the individual has two legal options: shed the debts through a humbling act of filing for bankruptcy, or find a new source of assets. Randall Bean, with Heather Tucci-Jarraf's assistance, tried to find a new source of assets, an alleged trust fund of government money in his name, but the money was not his, and along the way, the two of them defrauded the United States of $31 million. At the resulting criminal trial, they each asked to represent themselves, a request the court honored after holding a hearing on the matter. That would be Ferretta versus California. That's your Ferretta hearing when you want to represent yourself. The trial court did not end well for either of them, as the jury rejected their array of fringe conspiracy theories. On appeal, they argue that the trial court should have forced them to accept counsel in view of their unusual beliefs. Because they knowingly and intelligently and voluntarily made this choice because of their self-lowering, does not require the individual to subscribe to conventional legal strategies or orthodox behavior, we affirm. For years, Randall Bean honorably worked in our country, serving as an Air Force electrical engineer. At some point, he became convinced that the government was spying on the public, prompting a self-described quest into the world of conspiracy theories. His internet research led him to the straw man conspiracy theory. The government creates for each new citizen, the theory claims, a legal identification called a straw man that allows the Federal Reserve to hold in trust that citizens inherit an unlimited value. Proponents believe that by filing paperwork with the correct verbiage, they can tap into these trust funds and use them as bottomless expense accounts. Timing is everything. This theory struck a chord with Bean at a vulnerable time when he owed money that he could pay on his vehicle, several credit cards, and 4 personal loans. Before long, he came across the work of Heather Tucci-Jarraf, which did not help matters. A former lawyer who once worked as a prosecutor and public defender, Tucci-Jarraf ran a website, posted videos, and contributed to talk shows about the strawman conspiracy theory. She also produced several faux legal documents that purported to allow individuals to access their secret trust fund accounts. Seeing Tucci-Jarraf as a visionary who could make a difference, Bean reached out to her. She committed to help Bean dispose of his old energy and move forward and be creative in getting his financial house in order. Bean found an outlet for his creativity. While browsing Facebook, he came across a video posted by an anonymous user under the moniker of Batman villain Harvey Dent. Huh, where have you heard that name? The video purported to teach viewers how to access the secret trust fund accounts, but in truth, it taught them how to commit wire fraud by exploiting a deficiency in the automated clearinghouse network that the banks use to transfer funds online. Bean discussed the video with Tucci-Jarraf. I'm just going to call her Tucci, Heather Tucci. She offered her own advice on how to perform the technique and directed towards him potentially helpful documents. And I've never read this before, so this is my first time too, and I wanted to do this together so we can all learn and educate ourselves what not to do and what to do. Correct? What's legal and lawful. On the evening of July 3rd, Bean gave the Harvey Dent idea, well, that's a mouthful, idea a try. Logging onto his bank's website, he followed the video's instruction, entered the information it recommended. Account number, his own 9-digit social security number, routing number, the Federal Reserves. Using these credentials, Bean made fraudulent payments in full on his personal loans, his credit card debt, and his car insurance. Elated, Bean took to Facebook to spread the word that he just paid off all his debts with his trust account. Okay, this R stands for Reporter's Record, 165, probably volume 165 at 182. Easy as this was, Bean tried it again July 5th. This time, he bought certificates of deposit with Federal Reserve funds. With Tucci providing moral support through video conferencing software, Bean bought CD after CD. He didn't stop until his computer's mouse ran out of battery charge, then went to bed. Oh my God, you can't make this shit up. If I said that without reading this, you guys wouldn't believe a word of it, would you? He bought CDs until his battery and his mouse died. Okay, that would mean I would use this mouse right here, okay, until the battery inside died, which is a long freaking time. Whew. Bean awoke the next morning to find over 28 million worth of CDs in his bank account. Before long, he increased the total to 31 million. And before long, he started cashing the CDs. With his debt cleared up and plenty of cash on hand, he bought an $86,000 truck as well as a $500,000 motorhome that had 2 bathrooms, marble floors, and a fireplace. I can't make this up. Y'all go to this link. This is hilariously horrible. Horribly hilarious. I don't know which. Suspicious of his sudden fortune, one of Bean's banks froze his account. It also attempted to cancel the payments he made on his new truck and motorhome. That's when Tucci re-entered the picture. She advised Bean on how to protect his new assets by placing them in the name of a trust and prepared pseudo-legal documents on his behalf. Claiming to be Bean's lawyer, she made phone calls to one of the banks and a dealership to persuade them that he rightfully owned the money he was spending. Her assurances worked, and the bank stopped canceling the payments, but just for a while. By then, as it happens, a federal investigation had begun. On July 11th, federal officers learned that Bean planned to drive off the dealership lot in his new motorhome. Officers rushed to the scene, arriving just as Bean started the engine. I mean, this sounds like a bad movie. He refused to exit the vehicle, and agents had to remove him. One of the motorhome's other occupants provided officers with Tucci's phone number and requested that they contact her. On the phone, Tucci claimed that she was planning military officers arrested her in Washington, D.C., where she had gone after contacting the Secret Service to request a meeting with the president. Yeah, I can't make this shit up. This is like bizarro land. Bean and Tucci responded to their arrest with a flood of frivolous motions. They demanded hearings on their own identities, the identities of the arresting officers, the identity of the presiding judge. They asserted that the United States courts cannot hold anyone except by their own consent, and that the United States, a tad more plausibly, is a bankrupt corporation. They submitted hundreds of pages of pointless uniform commercial code filings allegedly related to something called the One People's Public Trust. Familiar with them? They mailed the court an itemized bill seeking payment of over $46 quintillion. On and on it went. Concerned that such contact might confuse a jury, the judge granted a motion in limine that barred the defendants from raising similar arguments at trial. Basically, a motion in limine is to quell something, to quiet it, to prevent it. Whew. Usually, they use a motion in limine for prior offenses not to be raised during trial, so it can't inflame the minds of the jurors and prejudice them against the defendant. They have no bearing during the bifurcated trial phase one, which is the guilt and innocence phase. However, they can be raised at the punishment phase, which is the second part of the bifurcated trial, phase two. The judge held a hearing for each of them, complete with the standard issue inquiries and cautions about self-representation, which is again Ferretta versus California, Supreme Court case law. The defendants provided some unusual answers, but after an extended colloquy, the judge concluded that they had knowingly intelligent waived their right to counsel and granted their request. As a safeguard, he granted their request to appoint standby counsel who can help the defendant during the trial and who can take over if the judge ends the defendant's self-representation. The defendants did their best. They cross-examined the governor's witness, introduced evidence, testified on their own behalf, and used closing statements to justify their worldview, but their best was not good enough. The jury convicted Bean of bank and wire fraud and both defendants of conspiracy to commit money laundering. The court sentenced Bean to 155 months and ordered him to pay over $500,000 in restitution. The court sentenced Tucci to 57 months. Bean and Tucci have had second thoughts about representing themselves. On appeal, they argue the trial judge should have saved them from themselves. No cause for reversal has been shown. The right to counsel in the Sixth Amendment as a paternalistic and liberation components to it. On one side, all the defendants have the right to counsel in criminal cases, along with the right to have government appoint counsel if the defendant cannot afford it, and all end ensuring that the government does not remove someone's liberty to live freely in a society without sound legal representation. Gideon versus Wainwright, Supreme Court case, that's a pretty much common standard. And on the other side, all defendants, whether lawyers or not, have the right to represent themselves, what amounts to the right to reject counsel and confront government alone. See Ferretta versus California. Right? Man, I know my shit. Okay, and here, this is ineffective assistance of counsel. This is Strickland versus Washington, because I'm sure that basically what they're claiming is their own self-representation was ineffective versus Strickland versus Washington. The holding in Strickland versus Washington is a two-prong test, and the test is basically, did my counsel do something, and had they done it, and this is phase two, or prong two, had they done it differently, the outcome of the trial would have been different. Okay? Without even reading. And they're probably going to cite Strickland in here. The two questions the trial court must affirmatively answer affirmatively for it allows self-lowering. Did the defendant expressly waive the right to counsel in a knowingly intelligent manner? Of course, that was the Ferretta hearing that they had, where they get an admonishment that, you know, you're your own worst enemy, basically. You cited some case for McBride. Yes, I've cited that case. Represent themselves, receiving all our inquiries. Okay, the judge gave the defendant a proper Ferretta hearing, right? What I just said. This is more case law. I mean, I can go on and on and on. This is bizarre. And I've read hundreds of trial records and appellate's case law, appellate case law, post-conviction case law, and I mean, yeah, I mean, if I just sat here and just told you a story and made all this shit up, and you know, basically was reading this without you being able to see it, you would just be laughing your ass off. You know, oh, fearless man, you're just like, you man, you dude, you're out there. Quit it. Stop. No, we're laughing too hard, man. Shut up, right? Well, you're looking at it. I mean, it's right here in black and white. Okay, we affirm. So, from the Sixth Circuit U.S. Court of Appeals, their next step is to the United States Supreme Court in Washington, D.C. on 1 First Avenue Northeast, 20043 or 53, I believe the zip code is. How's that for memory? With a application and petition for writ of certiorari. I filed many of those. That's their next step, which I'm sure that the Supreme Court's going to deny without written order, like they've done me many times. So that's the Heather Ann Tucci story. Wasn't that scary, kids? Scared the hell out of me. That's what they'll do. So, for all you people who've been like beating me up without seeing part 3 and only just watching the intro and putting your 2 cents in, watch part 1, watch part 2. Now you're watching part 3. And after I get done with this video, you're more than welcome to drop your little old 2 cents in the comment section. Otherwise, you've been forewarned and foreshadowed. Okay. Hang on. Whew, man. It's like 10 o'clock, and of course I'm getting tired. But the show must go on. We need to go back to the opinion. So let me get back to that. And we'll get into defendant Hauser. Here we go. Lastly, defendant Hauser argues that he did not commit forgery when he filed the financing statements because in merely filing financing statements, he did not file forged writings, even if the documents contain false information. I can't make this up. Furthermore, Defendant Hauser contends that the state failed to prove that the financing statements had a value of $250,000 or more because the collateral description is not the equivalent of value, and financing statements do not have an inherent value. Defendant Hauser cites the common law definition of forgery, claiming that forgery, quote, does not embrace false contents of a genuinely executed document unless the document, executed document, unquote, unless the document is a fraudulent filing on its face. Just saying. Proof of trial indicates that Mr. Birdsall personally saw defendant Usinger filing liens on the computer through the Secretary of State website. The victims who testified at trial testified that they did not owe defendant Hauser any money, had not entered into any type of arrangement, i.e. agreement, that would allow him to obtain a lien against them. All the finance statements at issue proclaimed an apparent values of more than $4 million. As testified by Mr. Burton, in our view, the evidence is sufficient to support defendant Hauser's convictions of forgery. Filing of fraudulent liens. They've already admitted to that. So, I mean, I can beat the dead horse if you want, or I can just get to the conclusion of this. Double jeopardy. They're trying to claim that because they were convicted of the filing fraudulent lien, that the forgery encompasses the same thing, and they're being twice convicted for the same offense. However, that's not the way the statutes read. Okay, I mean, I can read all this, but I'm giving you the Cliff Note version, putting it in a nutshell for you. Sentencing, same thing. Each defendant complains that it's about a sentence. The state argues the trial court did not abuse discretion in sentencing offenses within a range of sentences for their convictions. This is the case law supporting everything. Defendant Cromwell. And we get into a bunch of Cromwell stuff. He's claiming that he's mentally incompetent. Lyons. Cooper. This guy was following, people here in Houston, Texas. Rachel Donnelly. Oh, she's an attorney. I know who she is. Me? No, an attorney in Houston? No. No. Telling you guys, man, when it comes to the legal field, been there, done it. Yeah. Defendant Hauser. So we're almost done. 2 more pages. Are you ready? Good. So here we go. Yeah. Well, because this is the big crescendo. You read this, you're going to scratch your head. You're like, what? But I'm debating whether to show you something else or not. Because when I show you something else, you're like, But anyway, let me show you this. This way. Okay. This is Chris's video, 1099A, one more time. And as you see right here on this date, 12/31/2014, United States Treasury. This is their EIN number. Chris has his number covered up. Christopher Allen Hauser, Del Rio, Tennessee. $4 million, right? It's a 2014 1099A. Lien security. Chris has held this up, and he's clearly stated he's a multimillionaire. He possibly could be. However, does that show anybody to be a multimillionaire? Because I got a stack of them right here. I can pull one down and I can write out $4 million. Does that make me a multimillionaire? Show me a bank statement that you got 400 million in there. And I'll get to why I'm showing you this, because Chris pontificates regularly. Doesn't want your money, doesn't need your money. He's a multimillionaire, correct? He's a multimillionaire. Why does he have court-appointed counsel on appeal? You know, I'm going to go get Racehorse Haynes. I'm going to go get Johnny Cochran. I'm going to pull some of these big deal guys out of retirement. Who's the guy who represented John Gotti? I can't remember his name off the top of my head, but yeah, I wrote that guy a letter, and you know what? They didn't even open it up. They sent my whole sealed envelope back to me, telling me, no. We don't take outside unsolicited clients. We only represent those guys. Those guys. Yeah. God, I can't remember that guy's name. He's in New York. Yeah, he represented John Gotti, got John Gotti off all those. I'm like, hey, man, I want that guy. That guy's the shit. I'm telling y'all, been there, done it, man. So when I tell you things, it's through experience. It's wisdom. I'm not making this shit up. Yeah, I couldn't believe they sent me my envelope back unopened. No. Wrong place, wrong time. So anyway, let's get back over here to where we're supposed to be. Thank you, Chris, for being a multimillionaire. We appreciate that. All right. Now we're going to get down to the nitty gritty of the whole expose for part 3. Thank you for hanging in here with me. Like, subscribe, share, hit the notification bell. Tell the world. We're trying to figure out who Chris Hauser is, what his motives are, and why things are the way they are. Why Chris is a multimillionaire, and yet makes some of the decisions that he makes. So here's the story from the Tennessee courts.gov. Go look up the opinion of the Tennessee Court of Criminal Appeals. Defendant Hauser. Defendant Hauser had a separate sentencing hearing on the same day. He was convicted of 21 counts of filing a fraudulent lien and 21 counts of forgery. I'm going to stop right there because, yes, Chris has addressed this. He's been totally upfront, not trying to hide anything. Even posted the YouTube video of the Tennessee Court of Criminal Appeals hearing, just like I showed in part 2. Absolutely. Nobody's contesting that. That's not why I'm even addressing any of this. Okay? I'm going to get to the part right down here. Okay? I'm going to scroll a little bit more. And when you hear this, you're going to go, what? 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 What did he just say? Can you repeat that, Fearless? Okay, so this is the important part because this is going to give you, hopefully, if you have any kind of intelligence, it's going to open your eyes. It's going to make you think, like, what the hell's really going on? What? So whether or not Harvey Dent has connected Heather Ann Tucci to Christopher Hauser or Christine Hauser or whatever, or is it a coincidence they're just both in Knoxville? I don't know. Does Chris even know Heather Ann Tucci? I don't know. Does he know Harvey Dent? I don't know. Does Harvey Dent know Heather? I don't know. I don't know any of that. Okay? Have I asked him to be on my show? Yes. Chris instead's doing a live video on YouTube. Probably still doing it. More power to him. Congratulations, Chris. All right. Agent Irwin testified that defendant Hauser also filed liens against entities that were not included in the indictments. Okay, so he had more than 21 counts. Okay, they just didn't even bring these people into the picture. Like 21, we got plenty. Okay. And Chris is going back on appeal, challenging 9 of those. Really? Okay. So let's just say, Chris, okay, legal strategy, that you prevail and you knock 9 of those off. Let's just say you knock all 21 of them off. Guess what the state's going to do? They're going to go get these other entities that weren't included in the indictments, and they're going to give you another trial. And guess what they're going to do? In retaliation, they're going to smoke your ass and give you the maximum. That's what the prosecutor's going to ask for. And the jury just might give it to them. Be careful what you ask for. And like all attorneys know, if you don't know the answer to the question, don't ask it. Same goes for, what are you asking for? Make sure that you know what you're going to get before you ask. Just saying. These liens were filed against Knox County government, Loudoun County government, Tennessee Department of Safety and Homeland Security, Circuit Courts of Cott County, and Tennessee Department of Human Services Child Support. Well, why didn't you just go out and shoot everybody, right? I mean, you're basically poking the bear when you're inside the cave, and the bear's between you and the outside of the cave. Yeah, that's what it looks like. Okay. Might be a good idea. I don't know. Defendant Hauser's mother, Mary Hauser Larson, testified that defendant Hauser's behavior was not indicative of the way he was raised. She apologized for his actions. She acknowledged that defendant Hauser was in the Army. Ms. Larson was not under the impression that anyone was hurt by defendant Hauser's actions. Rebecca Hauser testified that she was married to defendant Hauser. She explained that defendant Hauser changed after he met defendant Cooper and paid defendant Cooper $6,500. Defendant Hauser informed her of the actions he was taking when he filed the liens, but she did not understand it. She claimed that if he knew it was illegal, he wouldn't have done it. Defendant Hauser testified. Apparently he testified at his own trial, which is a bad thing to do. But anyway, defendant Hauser testified that he was in the Army. He was discharged in 1990. He recalled that he injured his knee in the military in an auto accident, and after leaving the military, fell about 40 feet off a cliff and received significant injuries. Since that time, he reported being disabled. Defendant Hauser also reported dealing with post-traumatic stress disorder as a result of his military service. Defendant Hauser claimed that he planned to start a nonprofit called Veterans Adventures. Defendant Hauser explained that he got divorced from his first wife after his fall. At the time, they had 2 small children. Defendant Hauser eventually became frustrated with how child support was going. When he met defendant Cooper, he became interested in the process of filing liens. He paid defendant Cooper $6,500 for help. He explained that he thought what he was doing was legal. He admitted that he did not know all of the people against whom he was securing liens, and that he provided his credit card information for filing UCC documents. Okay, look, I'm not going to fault Chris for paying somebody to obtain some knowledge, or that he paid somebody to do some process that he really didn't understand and didn't think through, which is going to eventually get me to my theory. And it's my theory, nobody else's. And I don't know whether it's true or not. It's a theory. So, in sentencing, defendant Hauser, the trial court noted that he had a previous history of criminal convictions in addition to those necessary to establish the range based on his arrest for violation of an order of protection and other events that were not charged in the indictment. The trial court agreed that defendant Hauser's conduct neither caused nor threatened serious bodily injury. The trial court declined to apply several enhancement factors and at least one mitigating factor. And to pause right there, basically the enhancement factors would be prior convictions for some other things that I have not been able to find that don't pop up when I do a search, which is, to me, is odd because I should be able to find them. Anybody should be able to find them, actually. So I don't know what those particular enhancement factors, and generally those are punishment enhancement factors. And in Texas, that's under Section 12.42 in the Code of Criminal Procedure. And I'm at 1242D, a habitual felony offender. Yeah. Used to be a menace to society. Absolutely. Was that guy. But I have changed. Like I said, people change and they can do good and benefit society. The trial court sentenced defendant Hauser to 2 years for each of the 21 fraudulent lien convictions and 20 years for each of the 21 forgery convictions. As to consecutive sentencing, the trial court determined that defendant Hauser had an extensive criminal history, and I have no idea what that is. Okay, I don't know what extensive could mean to the court. I have an extensive criminal history, and I don't know what that looks like for Chris. You know, thankfully, he only got 20 years. With an extensive criminal history, they gave me 60. Yeah, 60. So I get it. I understand. Been there, lived it, done it, still living it. The trial court declined consecutive sentencing, ordering the sentences to be served concurrently, which means they did not stack the 2 on top of the 20 or the 20 on top of the 2, and they read them concurrently, which means they would start at the same time. And of course, the 20, as I explained earlier, the 20 ate up the 2, so the 2 just basically disappears, and you're doing the 20. For a total effective sentence of 20 years. The trial court denied alternative sentencing for defendant Hauser on the basis that it would depreciate the seriousness of the offense and would deter others. Defendant Hauser argues that the trial court erred in applying enhancement and mitigating factors. Enhancement and mitigating factors are advisory only. Even if the trial court improperly applied an enhancement or mitigating factor, defendant Hauser's sentence will be upheld as long as it is consistent with the purposes and principles of the Sentencing Act. Trial court did not abuse its discretion in sentencing defendant Hauser to a within-range sentence after the following procedure set forth in the Sentencing Act. Defendant Hauser is not entitled to relief on this issue. Okay? Because the range of punishment was within the sentencing guidelines. So in Texas, if you committed a first-degree felony, which would be a Class A felony, I would presume, in Tennessee, that's a presumption, I haven't looked it up. In Texas, it's 5 to 99 or life. That's a sentencing range. So if they sentence you anywhere between the 5 to 99 or life, they're within the sentencing guidelines. However, if you committed a second-degree felony, the punishment would be 2 to 20 in Texas. If you committed a third-degree felony, it's 2 to 10. So if they sentenced you to 15 years for a third-degree felony, they sentence you outside the sentencing range, which for there they have a sentencing act. Okay, so that would cause you to be entitled to relief because the sentence was not within the range of the sentencing. Okay, so they were within the range. So that dog don't hunt either. So basically, this is the end. There's Judge Easter signature, and that's the end of page 36. End of this instrument. So after going through all that, in my own personal opinion, have litigated multiple appeals, post-convictions on the state and federal level, state convictions and federal convictions, as well as going to the Fifth Circuit U.S. Court of Appeals in New Orleans and the United States Supreme Court in Washington, D.C., and pretty much every court in between Harris County, Houston, Texas, to those entities mentioned. I don't think Chris has a leg to stand on next month when his case is reviewed by the Tennessee Court of Appeals. Because this is the case right here. Okay. And there's their hearing date. I'm sorry. It was filed April 19th, 2021. And oral argument submission is April 6th, 2022, which is in generally 3 weeks. And there you go. Christopher Hauser, appellant defendant, Emma Ray Tennant. That's his counsel. Here's the case history. And generally, you can click on these and they will open up like right here, they would generally have PDFs that you could open up and you could read the instrument. However, in this case, most of the ones that offer the PDF to open up are, useless, mundane, insignificant filings that really wouldn't tell you anything. Um, Administrative order granting extensions of time to file the briefs. Basically, that's all they're doing, stalling for more time um, to write their briefs, do an investigation. So this is what I would do. This is my strategy. Okay. And then I use this time and time and time again. Let me Anti-Terrorism and Effective Death Penalty Act. Okay. This Cornell law. Section 2254. Now, this is Title 28, United States Code, Section 2254, and this is to challenge a state conviction in federal court. If you have a federal conviction, it'll be 28 USC Section 2255. All right. Now, this Anti-Terrorism and Effective Death Penalty Act of 1996, which Bill Clinton signed and a Republican Congress passed. This is how freaking crazy these people are. So you would think this would deal with terrorism and death penalties, right? Well, no, it doesn't. This created what's called a 1-year equitable tolling that every day you are not on a court docket, doesn't matter whether it's on the state or federal level, you lose a day of equitable tolling, and you have 365 days in that equitable tolling guideline to be in court. And once those 365 days are exhausted, then you lose or waive your right to challenge your state or federal conviction via federal writ of habeas corpus, um, under 2254 or 2255, respectively. So you lose your right to post-conviction remedies, because that's what it's called. Right now, Chris is in the direct appeal phase, which is a direct appeal of his conviction. So when he goes to the Tennessee Supreme Court, which is a wise decision because it keeps him involved. Now, my strategy would be if he's not doing it now, he really doesn't want to win. He really doesn't want to overturn his conviction, because what he should be doing right now is working on that 2254 now, today, because as soon as the court enters their final judgment, they're going to issue a decree. And once that happens, those 365 days start tolling every day you're out of court. So if you don't know what to do, Once that happens, you start losing those days. So you need to get into court and you need to stall, or you need to have this prepared so when that final judgment comes through, you've already dropped it in the mail. And according to the mailbox rule, it's served the day you dropped it in the mailbox. So you can electronically receive your final judgment and decree and drop it in the box same day, and you don't even lose a day of your equitable tolling to be able to obtain relief in the federal courts for your post-conviction remedies. Okay, so I'm not here to beat up Chris. I'm actually giving Chris sage advice, very wise advice, something that an attorney would charge him a lot of money to hear. Because how do I know that? Because I've done it repeatedly, over and over and over and over and over, not from only for myself, but for other people. So this is not a hit piece on Chris. The hit piece, I'd shut my mouth, wouldn't say nothing about it. But I'm actually giving him very wise information, okay, and telling him what to do. Because if you don't heed my advice, you're going to lose out, and you really don't want to win. You're just out there, wasting everybody's time, basically. All right. Now, I told you guys that, that was like a crescendo, the bombshell. Actually, it was because Chris paid somebody $6,500 to basically go to prison because they filed fraudulent liens without security interest or security agreement in place, which is part of the UCC process. And hey, I get it. Chris didn't know. He was probably going through some dire straits and was approached by somebody and they said they could get him out of a jam. And hey, okay, what's it take? And he got suckered, went to prison. Okay, what happened in prison? How did Chris get from not knowing a damn thing about the UCC or any of this process in 2017, go to prison, get out last year, and then now he's, 6 months later in October, he creates these YouTube videos and he's pontificating the 1099A process. Where did that come from? Where did all that knowledge come from? Where did he gain that? Did he learn it in prison? How long has this process been out? At least 2 decades. Somebody hit me up today. I was like, oh, I learned it from Chris. I go, well, you can go look it up on Radiant Clone. They're on YouTube. They teach the same thing. I had this stuff in prison. I had the same process. So this isn't anything new, just like Harvey Dent says. This is nothing new. This has been out there for a while. Has it worked? I don't know. Does it work for some people sometimes? Probably, maybe. I don't know. Nobody yet has been able to show me authenticated 100% absolute proof that this process works. Please give it to me. Send it to me. TheFearlessFloydShow at yahoo.com. I'd love to see it. I won't share it. It's a one-on-one. It's mutual. I act in honor, good faith, and clean hands at all times. That's my mantra. That's how I roll, baby. Okay? I have nothing but my reputation to stand on. And this channel allows me to effectuate who I am and how I stand. So, with that, I'm going to move on to this next bombshell. Okay? And it's not really a bombshell, but it'll definitely have you going, really, Fearless? Wow, you found that? Okay. So, whoops, wrong tab. And what you're looking at right here is the NewportPlainTalk.com, which is apparently a newspaper in Newport, Tennessee. This is the Circuit Court for Cotton County, Tennessee. City of Newport, Cotton County plaintiff versus delinquent taxpayers defendants. Okay, these are the docket numbers. Notice of sale. So let me read this to you because I know it's. All right. Notice is hereby given by the Circuit Court Clerk of Cotton County, Tennessee, that the following listed property and/or properties shall be sold for collection of delinquent taxes due to the City of Newport, Tennessee, and/or Cotton County, Tennessee, beginning at 9 a.m. Friday, March 11th, 2022, in the Circuit Courtroom at the Cotton County Courthouse in Newport, Tennessee, unless paid prior thereto. This is the Cotton County Circuit Court Clerk. I called them today. I was probably too late because I called them around 4 o'clock. They're already closed. Called this guy, Jeffrey Green. Where have you seen this name before? I think Chris filed a lien against that guy, right? 4 million, 6 million, 8 million, 12 million. I don't know. I called that number, got a recording, went through their little prompts. So, yes, I did my due diligence. I can show you on my phone, as always, but I'm not going to. So, what's in this, Fearless? What's that say? Christopher Allen Hauser. $654.85. Bull Mountain Road. Property taxes. Uh, find it. Well, I had it earlier. I guess I clicked off of it. Remember how to find it again. Taxes. Oh yeah, that's what it did. I went to, bear with me just a second. There we go. All right. Yeah, I knew I'd find it. Okay. Cotton County property tax information last updated yesterday. Okay. SecureTennesseeTrustee.org. You can go look all this up yourself, just like I did. Christopher Allen Hauser, Bull Mountain Road, 2021, 2020, 2019, 2018. Unpaid, 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 unpaid. $76, $76, $95, $95, which I guess with fines, fees, penalties, all that adds up to 600 and change, like I just showed you. Uh, he was paying it up until 2017. And I guess I'm going to presume this is when he went to prison. This is why he was incarcerated. But, this is like stupid ass chump change. I blow that one night of drinking when I drank. Shit. Yeah, it's like freaking half a 8 ball. So I I don't even know what that property looks like. For all I know, it's got a stop sign on it in the middle of the median, something small. I don't know. I just know that there it is. Chris has unpaid taxes for a very infinitional amount. Uh, saw right here, $654.85. I told you, you're gonna be scratching your head, going, "What? How can that be for someone that has that much money in the bank?" I don't know. I don't get it. I don't know. There's a lot of unanswered questions. So again, hit that like button, subscribe, notification bell, share this video, leave a comment below. There's a link to to some of this stuff in the comments below. You can email me at TheFearlessFloydShow@yahoo.com. You can join my Telegram group, The Fearless Floyd Show. Um, you know, Thank you for sitting through all this, the intro and the 3 parts of this expose on who is Christopher Hauser, because we'd all like to know. And again, he was invited to participate in this. I texted him, I called him, I emailed him. I did everything I could to get him on the show. Obviously, at the beginning of this video, he was doing a live feed on YouTube, which I put on my show. Um, so don't beat up me. I'm not beating up Chris. Now, if I thought that the 1099-A process worked, because in my own experience and my own endeavors, it has not worked for me. I have followed through with filing a complaint in Ogden, Utah with the IRS Complaint Division and Investigative Division, and I've had no contact, no nothing. My bills went unpaid. Zip, nada, didn't work. That's my own experience. You may have something to work for you. Congratulations. I'm glad you found relief. However, can you show me that you did it twice? Two different things. Okay? And show me proof of concept, proof of success. You can do that. I'll put it all over YouTube. Okay? I ain't got no problem with that. I applaud Chris for trying and attempting to do something fruitful to benefit everybody, and the fact that he's doing it for free, it doesn't solicit for money. Admirable. Boom. 2 thumbs up, bro. 1 million views. Awesome. Could you potentially be leading people to do some unlawful, illegal things? That is highly potential due to the fact that people are coming into this are kind of in a rock and a hard place. I'm behind on my mortgage. I'm behind on my bills. I got all this credit card debt. I want a car, don't have a car, or I have a car, or I'm not uh, mature enough to comprehend and wield the wealth that, because of great wealth comes great responsibility. Some people don't have that, never will have that, and don't, you know, shouldn't have that kind of responsibility or that knowledge. So this is like a sacred thing, and I understand that, and I observe that, and I practice that. This isn't for everybody. It shouldn't be for everybody. So you shouldn't throw it out there on the road to feed all the stray dogs, because some of those dogs don't need to be fed. They need to be put down because they'll never be right. So that's my own opinion. Now, what my theory is what's going on. And this is my own theory. And Chris, you're more than welcome to come on and, we can do an interview and have a discussion. and you can rebut anything that I say. I don't have a problem with that. Or you may want to create your own video, put it on your own channel to rebut everything I'm saying. That's your choice. Okay. You have your own opinions. I have my opinions. All I'm doing is creating a reasonable opinion based on the evidence I am presented. Have I seen anybody utilize your process that has presented 100% bona fide, authentic, genuine, factual evidence that they have succeeded using your 1099A process? No. I had people tell me, yeah, but talk's cheap. I could have sat here and told you this whole story, and you'd have shut me down first 30 seconds. However, I backed everything up with documentation, 100% authentic, genuine evidence. Did I not? Yes, I did. Okay, because that's how I roll. I told you that 1,000 freaking times. So anybody, everybody, you're more than welcome to do that. So we can, put this, put this corpse to rest. Okay. Now this is my theory. My theory is Chris didn't know anything about this. However, he jumped in with some guys. He may or may not been a sovereign citizen. However, whatever. Okay. I don't really care. But he got entangled with this group of guys, or a guy who was entangled with another group of guys. Whatever that scenario is, you've read the record or heard the record. So my point being is he didn't know anything. He didn't know diddly squat. He didn't know anything about cracking code, redemption manuals, secured by creditor, UCC. He didn't know any of that because he paid somebody $6,500, which is quite a lot of money to pay somebody to send you to prison. So he did that. I'm not beating him up about that. I don't care whether he's been convicted or not. I don't care. I mean, you don't want to know all the heinous, horrible, disgusting, depraved trial records I've read. People sitting right next to me. Yeah. I've lived with a serial killer, one of the most prolific serial killers in the state of Texas, David Owen Brooks, absolutely, on the Clemens unit in the early 80s. Look him up. He passed away a year ago, May. Okay. Yeah. We worked together, lived together. We're in the craft shop together. Yeah. I know some real, fucked up people. Excuse me. Anyway, this is my theory. Chris didn't know diddly squat about any of this. Got involved with these guys, sovereign citizens. Went to prison. They already knew about him before he even got to prison because of the publicity. He was in USA Today, Southern Poverty Law Center, of course, the Knoxville paper. So they already knew him before he got there. All he had to do is say, "Oh yeah, I'm that guy." Okay, and when people think or presume or assume that you know about this process, okay, like flies on doo-doo. They will come and they will ask you questions. They will try to be your friend and blah, 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 blah. They want to exchange information. They want to exchange documents. How do I know this? Because I was in it. I lived it. And inside prison, he learned about all these different processes. One of them being the 1099 process, which clearly flows through the penal system, state and federal level. Absolutely. I had it in there. I had the forms, all of them. Had the complete way to fill them out. I still have them. They're actually on my computer because I sent them home and scanned them. Yes. Okay. So he learned about the process. So he got out last year. Definitely didn't want to do the SBC process. Didn't want to fuck with those. Excuse me. Didn't want to mess with those UCC ones anymore. Got wise. Don't want to step in that bear trap again. So he learned about 1099A process and thought, hey man, this might work. How can I do this? How can I put it together? So my theory is that he came up with this ingenious plan. 2 thumbs up, Chris. pat you on the back, bro. Man, if you did this and this is what you're doing, you're awesome. I'll give you your kudos. Absolutely. I'm gonna put that gold star on your chest. You're good. That he didn't know how to perfect the process. He probably attempted to do it multiple times and it didn't work for him. He failed, as I have. But he didn't know the follow through. So he said, let me create this YouTube channel and let me throw this out there bait and see what happens. And boom. He made some videos, got some nibbles, got some bites. Pretty soon, he's pulling men one after another. Wow, okay. This is blown up. This is more than I can handle. So how can I harness this and create it and make it effectuate, make it work for me? Oh, I'll create a Telegram group. It'll be the Chris Hauser study group. And we'll study the 1099 process. And I'll appoint all these administrators and moderators, and anybody who comes in off topic or negative or, doesn't stay with the narrative, we're going to throw them off. We're going to block them. We're going to delete them. That's what they did. And Chris has been trying to find this group to perfect the process. And of course, everybody knows about the Chris Hauser Telegram study group. Well, there's another group on Telegram that Chris doesn't tell very many people about. And those are the more brighter ones in the group who not necessarily are greedy. I don't know their motivations, but they have less greed than the majority of the people in the Telegram group. The ones that are crash test dummying all these dealerships without any knowledge. So what he's done is try to find a select group of people to perfect the process to get it to work. 2 thumbs up, Chris. This is my theory. Is it work? Is it plausible? Yeah. So within this group of people, Chris is learning more. He's learning about new documents, learning new terminology, and he's putting it out there in these videos. That's why you really don't see Chris do videos with other people like myself or all these other gurus. And I'm not a guru, and I never claimed to be a guru, and I don't want to be a freaking guru, okay? I've already did that. I did that in prison. I was a guru in prison. And I taught 13 people, and that's when I got investigated by the Secret Service, IRS, FBI, and Postal Inspector. Yeah. Been there, done that. I don't want to be a guru. I'm not a guru, so don't even put that title on me. Ain't happening. I'm not that guy. I'm not gonna be that guy. I'm not gonna be anybody's bitch. Okay. So Chris wants to be a guru. By all means, bro. Godspeed. All the best. That's what I do. Like again, this isn't a hit piece on Chris. Of course, as you can see, if you've watched this whole video, it's a lot of sage wisdom that I've given Chris. I've given him some sound legal advice. Absolutely. But there's plenty of unanswered, open-ended questions that just don't make sense. Because if I told you that, there's not a dog in my house, and all of a sudden you saw a dog walk behind me, you'd be like, he just told us he didn't have a dog, but I just saw a dog. What's up with that? See what I'm saying? Same thing. If you have $4 million, at least $4 million, because you claim to be a multimillionaire. Okay, listen, if you're a millionaire, you have at least $1 million. Why do you have an outstanding property tax bill of $654 and change? How come you can't pay your property taxes? So in my own personal phone call with Chris, 2.5 hours, which I showed you in part 1 of the video, I discussed with Chris, hey, I know some finance managers here locally in Houston. I can pretty much get any manufacturer vehicle that you'd like, from Audi all the way up to Volkswagen and everything in between, domestic and foreign. You want a supercar? You want some exotics? Got that covered too. The finance managers. Have I approached them with this 1099 process? Not hell no, but okay. Why? Because I'm not going to waste their time. I'm not going to abuse their time, their energy, any of that. They can be, look, the exotic car place, they got vehicles there from 60,000 all the way up to $1 million. You think I'm going to go in there and waste that person's time that can potentially be doing $1 million deal, even a multi-million dollar deal for something that may or may not work or work for this guy but doesn't work for anybody else? No, absolutely not. So I'm not going to beat up my contacts, my relationships by doing something that will not bear fruit. So all of you out there who are running all these dealerships, doing all this crazy shit, y'all need to stop. Y'all need to think about what you're doing before you do it, before you get a wreck. Because, eventually one of these crash test dummies in Chris's group are going to really screw up. And I guarantee you, they're not going to lay down and take the fall. They're not going to die on the sword. They're going to throw Chris under the bus. Absolutely. That's just how people are. They have no loyalty. They have no courage, no honor, none of that. So this is why I don't want to be a guru. No, 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 no. I'm just going to present the facts. This is what I did. This is what worked for me. This is what failed. This is how I did it. This is how I filled it out. Here's my forms. Here's my templates. I don't care. Okay. I don't want any money. I don't need any money. Okay. There's a difference. I don't even need to work. I work because I want to work. I work because I like those people. I've been in the business a long time. I go hang out. How you doing? How's your brother? How's your sister? How your parents? Wah, 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 wah. We just shoot the shit. Okay. I make good money shooting shit. Basically what I do. I don't work hard, but I work. That's cool. I like what I do. So anyway, back to the topic. Questions we have to ask. Why does Chris owe taxes? Why does he say he's a multimillionaire? And in my own personal case, Chris was um, elaborated on all the vehicles that he owned and, wanted to get a new vehicle. And I told him, hey, I got the hookup. Let's do the process and get you whatever you want. Here's the websites. Okay. So just go on the websites and pick out what you want. And I can have it shipped to your local dealership. Or I can have it shipped here to his dealership and you can fly in, pick it up, or I can go pick it up and have it shipped to you, however you want to do it. You can even put the shipping charges in the price of the car and have them prepaid. So we already know how much it's going to ship from Houston to Knoxville, where you're at, and we just put it in the purchase price, right? I don't know. Like I said, I reached out. Nobody sent in requests to be on my show. Thanks for hanging in there with me. I know this is long. Now you understand why it's 3 parts. I could have easily made it 4, but I didn't. So I hope I covered everything, didn't leave anything out. And Chris, by all means, brother, I'm here for you. All you gotta do is pick up the phone, call me. You can email me. You have all my contact information. No way is to belittle you. I think there's some open, unanswered questions that you should, you don't have to. You should probably answer. And you got this guy, Harvey Dent, just like, pounding you like a vat full of grapes, you know. And, I understand sometimes you got to ignore people and you don't want to rebut them, but, the guys, I showed you the email telling you what he's saying, and y'all can take that with a grain of salt. And I was surprised just as much as you were that Harvey Dent was mentioned in Heather Ann Tucci's court case. That was mind blowing. That whole case is mind blowing. Bizarre. This whole thing's bizarre. I don't get it, And when I see things like this that are bizarre, and I see these unanswered questions that shouldn't be there but are there, I see red flags. When I see red flags, I put it in the wind, baby. That's what I do. I don't want no part of it. just for the simple fact that Chris called himself a sovereign citizen in a court of law on the record, for the record, under oath, that's a little discerning for me. So I don't know how you guys feel about that, but that's not my cup of tea, not who I want to be associated with, not my association at all, not my status, not my standing. Mm-mm. Y'all know who I am, what I'm all about. Again, not a guru. Don't label me a guru. Want to leave some comments below, please leave them below. If you want to email me, TheFearlessFloydShow@yahoo.com. Go to my Telegram channel. That's new. We're going to be pumping it up over there. And it's 11 o'clock at night. I've been on this for quite a while. All freaking day I've been doing this video. And with that, peace, love, happiness, and, we're not in World War III. This is oppression. And hey, look over here, look over there, look over here, look over there, look over there, look over there. Oh, okay, you didn't see what I was doing because you was looking everywhere else, right? That's what's going on. So anyway, thanks for hanging in with me, and I'll see you in the next video. I'll do some more tomorrow. I'm gonna pump them out all week. With that, good night, my friends.